I'm Ben Meiselas from the MeidasTouch Network. In a new filing in federal court in the Southern District of Florida, it has now been officially confirmed that a key witness against Donald Trump and his co-defendants in the Southern District of Florida federal criminal case against Donald Trump, a key witness has officially entered into a non-prosecution and cooperation agreement with special counsel Jack Smith and Jack Smith's team of prosecutors. That individual we've previously identified as Yusel Taveras, the IT worker at Mar-a-Lago, who's agreed to cooperate in connection with Jack Smith's prosecution of Trump and Trump's two co-defendants, Waltine Nauta, who's Trump's assistant and valet, and Carlos de Oliveira, who is a maintenance worker at Mar-a-Lago. All three of them are defendants in the case that charges Donald Trump with willful retention of national defense information, as well as obstruction of justice and making false statements. So this filing, where this was officially revealed and confirmed, is called a surreply regarding the motion for Garcia hearing that was filed by Donald Trump's co-defendant's lawyer, Stan Woodward. Let me break down what this all means and also what Stan Woodward is asking for in this motion. So a surreply is not a typical motion that is filed or a typical type of filing that is filed. It's basically a reply to a reply. And so here, special counsel Jack Smith requested a Garcia hearing by filing a motion for a Garcia hearing. I'll explain what that means in a moment. And then Waltine Nauta's lawyer, Stan Woodward, filed a partial opposition, and then Jack Smith filed a reply, and then Stan Woodward, the lawyer for Waltine Nauta, asked to file a surreply, a reply to Jack Smith's reply. A Garcia hearing is a hearing that addresses potential conflicts of interest between a lawyer who is representing multiple defendants or a defendant and witnesses, where there is an adverse relationship between the clients being represented by the same lawyer. So if one client wants to testify against another client, that could create a conflict of interest, and you have to hold a Garcia hearing upon request so that the various parties are aware of the conflict, and one of the parties being represented, or all of the parties, can decide if that's the way they want to continue to have their representation, or if what they prefer to have is independent counsel or another lawyer. But they need to understand their rights. That's what a Garcia hearing is all about. And so in the reply to the Garcia hearing motion and briefing that was taken place, special counsel Jack Smith was also responding to a request that was made by Judge Eileen Cannon to explain the propriety of the Washington, D.C. grand jury. And Jack Smith explained, well, the grand jury in Washington, D.C. is still proper. It's that it was conducting business and was still receiving evidence, because one of the key witnesses who lied to it back in March of 2023, Yusel Taveras, the IT worker, recently admitted that he was lying and agreed to cooperate with special counsel Jack Smith and Jack Smith's team. And so because you had a witness lie before the Washington, D.C. grand jury and then told the truth after there was a Garcia hearing that was held in Washington, D.C., that's why there was still a D.C. grand jury that was taking place. And then a superseding indictment was ultimately filed in July because this witness, Yusel Taveras, admitted to lying, told the truth, and said, look, Donald Trump and Waltine Nauta and Carlos de Oliveira were engaged in a conspiracy to try to get me, Yusel Taveras, to destroy surveillance footage. That was a key element in the superseding indictment. So to that, Waltine Nauta's lawyer, Stan Woodward, who used to be representing Yusel Taveras, he's saying here, whoa, I need to file a surreply because the way Jack Smith is making it appear, Jack Smith's making it appear like I told Yusel Taveras to lie in March of 2023 to the grand jury. I never told him to lie. Taveras voluntarily appeared, and what Taveras did on his own, but I never instructed him to lie. And then here in this bizarre surreply brief, you also have Waltine Nauta's lawyer, Stan Woodward, saying that because they argue that the grand jury proceedings in Washington, D.C. were improper still, and then that's why Yusel Taveras changed his testimony.
60% of U.S. pork production comes from one company owned by China. And their hogs, they're given something called ractopamine, which is banned in 160 countries, including China. Yet you find this in your grocery store aisle every day. There's a better way. I'd like to tell you about Moink. That's moo plus oink. Moink delivers grass-fed and grass-finished beef and lamb, pastured pork and chicken, and sustainable wild-caught Alaskan salmon straight to your door. Moink farmers, they farm like our grandparents did. And as a result, Moink meat tastes like it should because the family farm, it does it better. The Moink difference is a difference you can taste, and you can feel good knowing that you're helping family farms stay financially independent too. I love that Moink is helping save rural America, and I know that you will too. Join the Moink movement today. Shark Tank host Kevin O'Leary called Moink's bacon the best bacon he's ever tasted. And Ring Doorbell founder Jamie Siminoff jumped at the chance to invest in Moink. Plus, they guarantee you'll say, oink, oink, I'm just so happy I got moinked. And I know I do, and I know you will too. Keep American farming going by signing up right now at moinkbox.com/MeidasTouch. Right now, and listeners of this show get free bacon in your first box. It's the best bacon you'll ever taste, but for a limited time. Spelled MOINK box.com/MeidasTouch. That's moinkbox.com/MeidasTouch.
You have Stan Woodward is asking Judge Cannon to ban Taveras from being a witness in the case against Donald Trump, which is just completely and utterly absurd. But then again, Judge Cannon before has done some fairly absurd things. But this is being raised in a surreply, which is very rare and again, very, very bizarre right here. And so one of the interesting things, though, when you look at the surreply brief is it has all of this first off, it's very hard to read because there's all of these like parentheses, there's all of these like it's all over there's like huge block quote footnotes. I mean, I don't know if you can see it. I'm going to pull it up right here on my phone. Oh, you can't see it. We'll just pull up the graphic. But the footnotes take up full pages. Like it's very poorly written. But if I'm trying to understand what it is that Waltine Nauta's lawyer is trying to do here is really just make this request to allow Yusel Taveras, to require Yusel Taveras not to testify. Because if you go into the footnotes, it basically says that Woodward is not opposed to a Garcia hearing being held. They just want the hearing to take place ex parte, meaning that Jack Smith shouldn't be allowed in the hearing. So what they're basically asking for in the footnotes is they realize, I think, how corrupt Judge Cannon is. So they're asking Judge Cannon to hold the hearing, just Judge Cannon, Stan Woodward, Nauta's lawyer, and Nauta to ask Nauta about the conflicts. And obviously Jack Smith doesn't want that to happen because you then have kind of, let's face it, Cannon's like on Team Trump. The idea is you want to be able to advise the potential client that these conflicts may be the reason that you are being prosecuted because Trump is paying for the lawyers who are representing you to have Trump's best interest and creating all of this legal quagmire and all of these conflicts of interest that ultimately are resulting in you being prosecuted. And that environment with Judge Cannon, Stan Woodward, and Taveras is something that would still be, likely have a lot of apply a lot of pressure to Waltine Nauta to think that he's beholden to Donald Trump as well. And then here, if you look at it, what it says is the special counsel office's manipulation of the United States District Court for the District of Columbia achieved its penultimate goal. It is telling that the non-prosecution agreement has ultimately offered Trump employee 4 was not offered before the district court had agreed to appoint conflict counsel, meaning before Judge Cannon did anything. And so it's saying that it achieved its penultimate goal as though the district court in Washington, D.C. was like manipulated, like as though Judge Jeb Boasberg, a renowned district court judge in D.C., was manipulated by Jack Smith. And ultimately the manipulation led to what? Obviously there's no manipulation. Employee number 4 admitted to telling the truth. And don't we want the truth? Don't ultimately we want employee number 4, Yusel Taveras, to state what accurately happened rather than continuing down a path of lying and committing perjury and covering for Trump. And then, yes, there's a non-prosecution agreement entered for cooperating witnesses. That's the way the system is supposed to work. What's so backwards about this motion filed by Stan Woodward, Walt T. Nauta's lawyers, what you want the result to be? This is what they're basically asking Cannon. Hey, Cannon, we think that it's improper that the witness didn't continue to lie. And oh, by the way, we're not the reason that the witness was lying in the first place. Did I get that straight? That is basically what Stan Woodward is requesting Judge Cannon to do here. But in this motion, we learned that Yusel Taveras has officially entered into this non-prosecution agreement and is testifying against Donald Trump. And now Walt T. Nauta's lawyer, Stan Woodward, wants to say to Judge Cannon, hey, rule that can't occur. So anyway, that's what's going down. Go check out MeidasTouch.com for more.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.